LiberalViewer presents.
So another kind of silly argument that has broken out over marriage equality. This is a federal judge in district court judge in Alabama has found the Alabama constitutional amendment defining marriage as between one man and one woman as a violation of equal protection. And I want to show how Bill Maher talked about the issue in his monologue on Friday night's Real Time, the joke he made about this issue and what's happening in Alabama and the definition of marriage in Alabama over in this clip.
Now, down in Alabama, they are having a big fight. Have you seen this about gay marriage? The federal court down there actually says it is legal. But to prevent that, get this, 28 counties in Alabama are refusing licenses, marriage licenses, to anybody. That's how important this is to them. They are traditionalists, boy. You got to give them that. They believe marriage is not just anything. It is defined strictly as a union between a man and his sister.
So yeah, that's kind of the joke take on what's happening in Alabama. But next I want to show reporter's take on it. This is ABC's Steve Osunsami gave a report on ABC's This Week with George Stephanopoulos about what's going on in Alabama. And there's some quick clips from the Chief Justice of Alabama Supreme Court, Roy Moore, here. But I'm going to show some extended clips from Roy Moore because he was actually on Fox News Sunday. Anyway, here's the report on what's going on in Alabama on marriage equality generally in the nation and the Supreme Court's upcoming April oral arguments and June decision, most likely, all described over in this clip.
In the fight over gay marriage in Alabama, the latest blow is from a federal court in Mobile, telling county judges to take down signs and start marrying gay couples.
We've waited 33 years for this.
Carrie Searcy and Kimberly McKean are at the center of the case. They sued the state when their son needed surgery after the hospital refused to recognize both of them as parents.
We needed that legal protection. It was never about marriage for us. It was all about protecting our family.
Same-sex marriage is now legal in more than 30 states. But when a federal judge sided with Searcy and McKean, striking down a gay marriage ban in Alabama, no one less than the Chief Justice of Alabama's Supreme Court stepped in the way.
Definition of marriage is between one man and one woman.
The famously anti-federal Chief Justice Roy Moore is still ordering county probate judges to refuse marriage licenses for gay couples, arguing that he and the county judges are not required to listen to the federal judge in Mobile.
Under federal law, federal courts can't mandate their decisions upon state courts.
One of the country's most famous constitutional law professors disagrees.
We have a supremacy clause in our Constitution. When federal law is in conflict with state law, federal law wins out.
The U.S. Supreme Court will decide the case in June, one of its justices showing her hand.
As more and more people came out and said, this is who I am, and the rest of us recognized that they are one of us.
But the fight in Alabama could continue even if the Supreme Court sides with gay couples. The resistance here to the federal government is strong. For This Week, Steve Osunsami, ABC News.
So speaking of the resistance to marriage equality being strong in Alabama, I want to show a couple clips from the Alabama Supreme Court Justice Roy Moore appearing on Fox News Sunday, and his arguments are just not really good legal arguments. You know, being a lawyer myself, especially the second clip I'm going to show, but even this first clip where he tries to argue that judges don't make law. I mean, they call it case law. I have like books and books full of judge-made law. That's basically his argument here in response to Chris Wallace, who does some pretty good questioning. Here's the first clip of Alabama Supreme Court Justice Roy Moore, who's trying to avoid complying with the injunctive relief given by the federal judge, finding that, you know, same-sex couples have to be issued marriage licenses in Alabama. Here's how Roy Moore is trying to avoid that in this clip.
Here's what President Obama said this week about this case.
and what he said about you. Here he is, sir.
When federal law is in conflict with state law, federal law wins out.
Was there anything you'd say to him?
I think that the courts at the federal level will have something to say to him.
Mr. Chief Justice, your reaction to President Obama's comments?
Well, I'd like to tell President Obama that he's entirely correct. Federal law does trump state law. But what this Harvard professor, who is president of the United States, does not understand is that a trial court's decision on the constitutionality of a federal question is just that. It's an opinion. It may be law of the case before her. It is not overturning the Alabama Constitution. Federal law is not made by judges. That's something very basic, something Speaker Boehner has just referred to about the constitutional violations of this president and the Supreme Court. We are seeing this. Those interpretations are not law. If they were, then the legislature would have no role. Legislators are to make law. Congress is to make law. The United States Supreme Court Constitution is law. So is the Alabama Constitution. We have a fundamental misunderstanding in our country that federal courts, by their mere utterance, make law. They do not make law, sir. They make law of the case applicable to the parties before them.
But, all right, this gets a lot into the weeds, and this isn't a law class. You heard the Chief Justice. I'm not a lawyer. But what if the U.S. Supreme Court hears the case in April and decides in June that there is a constitutional right to same-sex marriage? You have been, forgive me, a little fuzzy on this. You said at one point you would recuse yourself. What does that mean?
That means if a case comes before me and the Supreme Court has decided what marriage is, then that would control that case, but I would not be bound thereby. I could recuse or dissent, as a justice from Delaware did in the Dred Scott case in 1857. They ruled black people were property. Should a court today obey such a ruling that is completely contradictory of the Constitution? You know, Justice...
But I guess what I'm asking you is, I understand you'd be unhappy and you say you'd recuse yourself.
Sure.
But are you saying if the Supreme Court rules that Alabama does have to abide by the Supreme Court's ruling?
State courts are bound by the rulings of the United States Supreme Court. But just like Benjamin Curtis did, he said that when a strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of laws, is abandoned and the theoretical opinions of individuals allowed to control its meaning, we have no longer a constitution. We're under a government of individual men who, for the time being, have the power to declare what the Constitution is according to their own views of what they think it ought to mean.
So that's actually a pretty good recitation by heart of the dissenter in the Dred Scott decision that said that slaves were property, or although the thing is, under the Constitution at that time, slaves were property. It took like the 13th, 14th Amendment to get rid of slaves being property, and so I guess, and then plus in this next answer he also talks about Plessy versus Ferguson, and that was the law of the land for a while. But well, I'll talk about that a little more after you see this next question from Chris Wallace, where, like I said, you have to give Chris Wallace credit for asking fairly hard or difficult questions. Here he actually brings up Justice Roy Moore's history with the Ten Commandments monument in Alabama, where he was actually found to have violated judicial ethics, and Chris Wallace actually brings it up over in this clip.
We just have time for one last question. This is not the first time that you have run up against the federal courts. Back in 2003, you ignored a Court of Appeals, U.S. Federal Court of Appeals ruling that you must remove a 2-ton granite monument of the Ten Commandments from the state capitol. At that point, sir, Alabama, a state ethics panel, said that you had to be removed from office because you had put yourself above the law. Aren't you doing the same thing now, sir?
I was obeying the First Amendment of the United States Constitution, which does not prohibit the acknowledgement of God. When federal courts start changing our Constitution by defining words that are not even there, like marriage, they're going to do the same thing with family in the future. When a word's not in the Constitution, clearly the powers of the Supreme Court do not allow them to redefine words and seize power. The power is not delegated to the United States by the Constitution, nor prohibited by it to the states, or reserved to the states respectively, or to the people. This power over marriage, which came from God under our organic law, is not to be redefined by the United States Supreme Court or any federal court.
But they may do it. Chief Justice
Moore, well, they may do it, but they may do wrongfully, just like they did in Dred Scott and Plessy versus Ferguson in 1896, where they said that separate but equal was the policy of the United States.
I understand that, but when the Supreme Court rules, the Supreme Court rules. Chief Justice Moore, we're going to have to leave it there.
Now, actually, one of the reasons Plessy versus Ferguson was overruled by Brown versus Board of Education was some really good lawyering by the NAACP and Thurgood Marshall, who was the lawyer for the NAACP at that time, where they showed factually that separate but equal was inherently unequal, that they gathered all this information about the difference between the white schools and the black schools, and so they actually proved that Plessy versus Ferguson was factually wrong, that separate but equal wasn't on the ground equal. So that was one reason that Plessy versus Ferguson was overturned. And like I said, Dred Scott was actually probably a correct interpretation of the Constitution before the Civil War, and the 13th and 14th Amendment got rid of slavery and gave equal rights to everyone, born in the United States, even if they were at one time a slave. And anyway, I want to show one more clip on this. This is shows one of the probate judges whose job it is to actually issue marriage licenses, and this person seems a lot more reasonable and not going to listen to what Supreme Court Justice Roy Moore has to say, I guess. So this is a little bit of a hopeful sign that there are reasonable people in Alabama, which I'm sure there are. That this is a probate judge. His name is Stephen Reed. Over on This Week with George Stephanopoulos, though Jonathan Karl was filling in for George Stephanopoulos on ABC this morning here.
To make a decision.
And, if you look at polls, though, in Alabama, of course, Alabama approved that ban on same-sex marriage back in 2006 with over 80% voting yes. And even now in Alabama, look at the latest poll, 59% say they oppose same-sex marriage. Aren't the people of Alabama essentially with Judge Moore on this? Does that bother you?
No, no, that doesn't bother me at all. I mean, we're a nation of laws, not of men, and so we're sworn to uphold an oath in the probate court, and that's what we do. We uphold the oath as it relates to the state constitution and the U.S. Constitution, and so we understand that we can't bring politics and personal feelings into decisions that we make day to day.
So, like I said, even though I guess 80-something% of Alabamans voted for that constitutional amendment, and 59%, and that was 2006, and 59% of them still support a ban on marriage equality. I guess looking at that probate judge, Stephen Reed, it seems like there are still some reasonable people in Alabama. And the other point, I guess, before I leave it, that you should keep in mind is the fact that the Supreme Court is allowing same-sex couples to get married in Alabama means they're probably not going to overturn marriage equality with their ruling in June. I mean, you never know for sure, but it's really hard to take away people's marriages once you've given them their marriages. So they're not going to do anything that's going to upset marriage equality in Alabama, or probably in just about any state. But I want to know what you think. If the U.S. Supreme Court is allowing same-sex couples to get married in Alabama, does that signal a ruling that won't take away those marriages this spring? And regarding people like Justice Roy Moore, will those who oppose marriage equality in Alabama put up less resistance than those who opposed racial equality 50 years ago?
YouTube, you decide.